Minister.
Good morning, sir.
This may be a slightly unconventional way to start a cross-examination, but I've told the Commissioner this already, and I'll tell you. I'm old-fashioned enough, or maybe naive enough, to think that when a former cop comes to a solemn proceeding like this and swears to tell the truth, the whole truth, and nothing but the truth, that's what he's going to do. And I think when you came here on the 10th of April and gave your evidence, that's what you did. But I do have to ask you, so let me just put it to you. On the 10th of April, when you gave your evidence to this commission, did you tell the truth, the whole truth, and nothing but the truth?
Yes, sir. I've testified very many times and taken that oath, and I believe very strongly that it is appropriate and necessary to tell the truth, the whole truth, and nothing but the truth.
That was very much my impression when I saw you here that day. Sir, this warrant, well, let me back up and say you told us the truth, but at that point, we weren't talking about 54 days, and I gather that's because you weren't aware of this 54-day period when you gave your evidence on the 10th of April. Is that right? I
have no information even now other than the timeline that's been presented to me, what transpired in the interval prior to the date in which I actually received and signed the warrant.
Okay, thank you. Now that you have since learned that there was this 54-day interval, do you know now why it took 54 days?
No, not entirely. I followed some of the evidence that has been presented here, not exhaustively because I'm busy, but I followed it and gained some understanding of some conversations that I was not aware of at the time that took place.
Right, thank you. And have you discussed it with Ms. Astravas since and asked her why did it take 54 days?
No, sir, I have not.
Thank you. Do you accept, sir, that 54 days is much longer than it should have taken?
I understand the concern with the interval of time that's been identified. Again, as I've testified, I have no information about what transpired during that time that could have caused that length of interval, other than the testimony I've been made aware of here.
So I think you're saying that you can't accept that it was too long.
No, again, my expectation would have been if there were concerns with respect to the interval first of all, if I may, I expect that there is a certain amount of due diligence that takes place between the agency, the deputy minister, and my office. I believe that in every case takes place. If there had been any concern with the length of the interval, my expectation would have been that either the agency head, the director of CSIS, or the deputy minister or my chief would have brought that to my attention, and none of them did.
Yes, no, I've heard your evidence on that. I appreciate that point. There is concern outside in the rest of the world. I think it's fair to say that 54 days is awfully long. And of course, you've heard now, you didn't know at the time, but you've heard now that even the affiant was prepared to tell the federal court that that was unusual. So what I'm asking you is, knowing what you know now, can you accept that 54 days was longer than it should have been?
And again, I have no basis to come to that determination because I don't have all the information about what was transpiring during that interval. I accept that the affiant was concerned. I understand the concern the affiant would have. I've been an affiant myself, but at the same time, again, I think this hearing will determine whether or not there was any justification for the interval that took place. Based on my limited knowledge of it, I'm aware of it. My expectation always is that these things be dealt with all due diligence, but as promptly as necessary.
Yes, there absolutely has to be the due diligence, and you know that very well. You've explained that you've done many of these before. It needs to be done promptly, and the reason for that is that every day that goes by where the intelligence agency thinks it needs these powers but doesn't have them is a day where, lacking those powers, it cannot advance its investigation. It may be losing opportunities to gather evidence. And so that's why it needs to be done promptly. Do you agree with me that far, sir?
Well, again, my expectation, if I may, sir, would be if the CSIS had that concern, the deputy director would have communicated that to me.
I guess what I'm suggesting, sir, is that there's always that concern with any warrant, whether the director tells you in a particular case or not.
Again, my expectation is if that concern existed, that the deputy director would have, or excuse me, the director of CSIS would have communicated that to me, and he did not.
I see. You explained that while you didn't know about this particular warrant application and the target of the warrant application until what I'll call day 54, you had previous discussions with the director about the target of the warrant application, right?
I have previously testified this morning that several months before the day in which I received the warrant application, I had received a briefing from the director that spoke to the subject of the subsequent warrant.
Right, thank you. That's what I'm getting at. And having had those previous discussions, did you ever...
If I may be precise, a discussion.
A single discussion?
Yes.
All right, thank you. And having had that discussion, did you subsequently discuss with your chief of staff or anyone in your office words to the effect of, if CSIS brings me a warrant about this person, bring it to my attention straight away?
I did not have such a conversation simply because CSIS had not indicated to me their intention to bring forward a warrant until I actually saw it.
Understood. And likewise, did you have a discussion with anyone in your office to the effect of, if CSIS brings me a warrant about this person, I'm not in any hurry about it?
Absolutely not.
Thank you. There was some discussion about warrant renewals versus warrant applications. I just want to be clear, this wasn't a warrant renewal, this was an application.
That's correct.
Thank you. I'll ask the court operator to turn up WIT 159, please. At paragraph 16, please. Thank you. The paragraph reads as follows: as to whether there were any systems or procedures that you, sir, might recommend when dealing with politically sensitive warrant applications, example, warrants targeting members of the governing party or an opposition party, Minister Blair testified that the oath taken by the Minister of Public Safety supersedes all political considerations, and that the Minister has a responsibility to the country to do his job without fear or favor. That's a very admirable sentiment, sir, and I commend you for it. The reason why, and I would expect nothing less from a former chief of police, if I may say so, the reason why that is, let me put it this way. Was this a warrant application that required you to exercise that consideration to do your job without fear or favor?
I will tell you, when this warrant application was put before me, I never considered anything else other than my statutory responsibility to review and, if appropriate, approve the warrant. There was no other consideration, and certainly no political consideration.
No, I understand that, and I heard you say that this morning. But your evidence here is that there was some discussion of politically sensitive warrant applications and what the obligations of a minister are where dealing with politically sensitive warrant applications. And what I'm suggesting, sir, is that in your evidence behind closed doors about this, you weren't discussing it in the abstract. This actually was relevant to the warrant that we're talking about, because this was a politically sensitive warrant application.
Sir, I might suggest that your characterization is not correct. A particular question was put to me with respect to what was characterized as a politically sensitive warrant, and I tried to make very clear that my oath as the minister responsible under the Act to approve those warrants superseded any political consideration. And so whether or not a warrant might be considered politically sensitive is not, in my opinion, a relevant consideration. The only consideration is the law and my statutory requirement to fulfill my obligations under the law.
Yes, yes. And I'm asking, in short, was this a politically sensitive warrant application?
Well, I think we're getting into subject matter of the warrant, and we would object to that question on national security grounds.
Well, Commissioner, this is the evidence that this witness has already adopted, so I'd like to ask you to rule on that objection.
I think you're going too far, and
Thank you.
we'll write down the question, and if need be, I will follow up on the question.
Thank you. Sir, on the issue of the various intelligence products concerning my client, Mr. Chong, I appreciate that you didn't see them and you have various explanations for why you didn't see them. Do you agree that you ought to have seen them?
Frankly, I have not. I don't believe I provided various explanations. I've simply said I didn't receive them, and I think that's been corroborated by the testimony of others. So, to be clear, I just did not receive them. And secondly, as I've said also in testimony, I would have liked to have known that information. I would be concerned about any threat against any Canadian, including my colleagues, members of Parliament. And I was not made aware of this information. I'm not suggesting that I would have directed CSIS to do anything else other than the things that it did, but I would have certainly asked questions about what steps were being taken to ensure the safety of anyone who was being targeted for political interference.
I think you told Ms. Dan this morning that you'd never seen an issues management note.
They were not shared with me.
I mean, that sort of document. I'm not talking about the particular issues management note concerning my client. I think what you told Ms. Dan is that you had never seen any issues management.
I don't recall ever having one of those issues management documents, as it's been entitled, was ever presented to me.
CSIS's evidence previously in this commission has been that it was sending on average 2 to 3 a week. I don't know that they were all addressed to you, sir, just to be clear, but that's quite a volume. So I take it then that there may be other intelligence products that went in the form of an IMU that were addressed to you, but that you never saw.
And again, the document that was shared with me today wasn't addressed to me. And
The IMU is addressed to you, sir.
I believe it indicates that but on the email list that was provided and I was questioned about, I didn't recognize any of those addresses.
No, I appreciate that it didn't go to your email address.
Thank you.
But no, I understand that. But it says for distribution to the Minister of Public Safety, and that was you at the time.
And as I have testified, that information did not get to me and was not
But
shared.
I understand that. And what I'm saying is that if you've never even seen an IMU before, goodness knows how many other things you were meant to see that you haven't seen.
Well, And again, I absolutely understand and accept that the director of CSIS intended that I see it. Unfortunately, the steps that would have actually allowed that to happen did not take place.
You have explained in your evidence, and you said again this morning, that upon learning the story in the Globe and Mail and that there may have been things that didn't get to you, you asked your officials in your office at the time to look into this and figure out what happened. And they concluded that these materials hadn't got to you. Sir, the evidence that we've all heard from Ms. Estravis is that that was down to a failure by the department. As you know, Mr. Stewart, the Deputy Minister, sees it differently. There's a disagreement about that. What I want to suggest to you, sir, is this. You were the Minister of Public Safety, and you were responsible for that department, yes?
Yes.
You were also responsible, of course, for your own office.
Yes.
And as Minister of Public Safety, you also have responsibility for the service, right? Yes. And so whether the blame in any particular case for failing to communicate some intelligence product to you can be properly put on the director and the rest of the service, or on the deputy minister and the department, or on your office, one way or another, at the end of the day, you are the leader of all those organizations, and the responsibility for intelligence not getting to you when it should have is ultimately yours. Do you accept that the responsibility for these various failings, we can point all around town as much as we like, but at the end of the day, constitutionally, you are the person responsible. Do you accept that?
And first of all, I very much accept, if I may answer that, I very much accept the principle of ministerial responsibility, and I agree that I was at all times responsible for the Department of Public Safety and with the 5 agencies that were under that portfolio. It was, unfortunately, impossible to know information that we were not receiving from them until it subsequently became public, that information existed and had not been shared. The responsibility that you reference is to fix that, and steps were taken following the pandemic and when it became known that that information was not reaching the minister's office, that steps were taken to ensure that that took place. I believe that's been the testimony that corroborates that. And so I believe the exercise of that ministerial responsibility, if information is not reaching its intended target, then it needed to be fixed. All I can also testify to is that information, notwithstanding, it may have been the intention of CSIS to get it to the minister's office, they were not able to make that happen, and it did not get to us.
Thank you, Commissioner. Those are my questions. Thank you,
Thank
Minister.
you.